require that he give Mr. Rosenbaum adequate notice that he is withdrawing from the fight or the attack. I think under those circumstances, that's impossible to do. But more importantly, I have found a case, it's from Kenosha, on provocation and what that means in terms of a self-defense. That is State versus, and I'll just spell it, it's Boughneit.
Can you spell one more time, please?
Boughneit. It's at 97 West 2nd, 687. And in that case, there was a gentleman in a diner, and people walked into the diner, and he started to harass them. He tried to grab the women, harassing the women, verbally accosting people. And one of the men that the women were with came over and said, "You need to apologize." The defendant said, "Let's go outside." So they go outside. The defendant ends up going to his car, picking up a shotgun and shooting the man in the face. And the argument was, did he provoke this? Now, there was testimony to everything that I just told you. Did he provoke that by starting the fight, sexually harassing the women, using the language he used, and then asked the guy to come outside? And the court said he did. So the provocation instruction is clearly appropriate. I don't believe there's sufficient evidence in this record to support the idea that Mr. Rittenhouse provoked this attack. I don't think that that's there. So I understand that it doesn't require that they follow that and say, well, he did provoke it, but I think there has to be evidence to support that. And I don't think that photograph in and of itself, which is obviously open to interpretation, supports the idea that they have to or should consider whether or not that was provocation at that point.
May I respond? I agree the photograph alone would not give the basis for provocation. The photograph is the last piece of evidence that was submitted on this. Detective Antorini testified to it. We have pointed it out on videos. We pointed it out to the defendant on the video, and he gave what I believe to be a lame explanation for it. And again, the defense's own exhibit has it circled on there as it happening. So I believe there's plenty of evidence that Mr. Rittenhouse did raise this rifle and pointed at someone off in the distance, actually Mr. Zeminski. And let's not forget also, I've not given my full argument on provocation yet, the FBI video, well, let me go back. The Corey Elijah and the Drew Hernandez, actually Frank Hernandez videos, shows the defendant walking behind Rosenbaum, Mr. Rosenbaum, on the way to this car source area. At some point, Mr. Rosenbaum begins running. We see that on the FBI plane footage. Our argument is that Mr. Rittenhouse then begins running and following Mr. Rosenbaum. That he follows, if not the whole way from the Ultimate gas station, then Mr. Rosenbaum starts running. That provokes the defendant, who is actually very slowly and casually walking for quite some time, seemingly, to then go and follow Mr. Rosenbaum there. He then, and the defense's argument is that this is some sort of ambush. And I don't know how you ambush someone that you don't know they're there, but we'll put that aside.
What?
I don't know how you ambush someone you don't know is coming, but we're going to put that aside. So the defendant runs onto the scene and then is seen by testimony and video evidence gently putting the fire extinguisher down. He says he dropped it, but he places it on the ground and he raises the gun, and I disagree about the left-handed thing that Attorney Trofsky just said, and raises it at Mr. Zeminski. That is all in evidence. It's in a defense exhibit.
Can I see that? Is that readily available? Bear with me 1 second.
the state's position is that the running after Mr. Rosenbaum probably in itself was enough to provoke the attack, but putting that aside, certainly raising a gun and with no basis for any kind of self-defense, there's no one around him at the time except an individual in a wheelchair who's behind him. He raises his gun, I would guess, because he thinks there's vandalism going on, but we don't know that because the defendant denied that he did it. And then Mr. Rosenbaum approaches, he somewhat drops the weapon, he keeps two hands on it, and then he has a duty to retreat at that point under provocation, and then he runs. I understand why this instruction is problematic for the defense and for their version of events, but that does not change the fact that pointing a gun, which is in the evidence, is provocation. The defense is
Well, wait a minute, no. Oh, you will, see if you can find it. Which exhibit are you talking about?
Talking about the compilation video that the defense put into evidence, I believe it's 41.
I have it on my screen right now on my